Thank you, listeners, for joining Mayer Brown's Global Financial Markets Initiative teleconference series. Today's call is titled Derivatives Regulatory Changes on the Horizon under EMIR Refit, the Global Margin Rules and SFTR. I'm Edmund Parker. I'm the Global Head of the firm's Derivatives and Structured Products practice. First, a couple of housekeeping items. As regular listeners will know, this call is being recorded. We will be emailing an audio link to all participants should you wish to listen to the teleconference again, or if you'd like to forward it to your colleagues. In addition, the recording is going to be available as a podcast on your preferred podcast platform. And since we don't have a Q&A session, please do send any questions regarding today's topic by email to gfm@mayerbrown.com, and we will respond promptly. That's the same email address on your invitation email. Now for a brief introduction of our speakers for today's call. My practice covers all areas of derivatives advice, in particular the topics we're covering today, and joining me from our Mayer Brown Derivatives and Structured Products team are EMIR Khoo and Marcel Hörauf. Emma's a senior associate in the London office, focusing on non-contentious regulatory law with a particular focus on derivatives. She regularly addresses compliance issues and cross-border issues in the financial services sector, including the authorization of financial institutions under EU and UK law. Marcel is a senior associate in our Frankfurt office. Marcel's practice includes regularly advising on OTC derivatives, CCP clearing, and financial market infrastructure, such as MiFID II, MiFIR, and EMIR, as well as secured lending transactions and repos. So perfect for today. And with those brief introductions, I'm pleased to begin today's presentation. So today we're going to be discussing EMIR Refit, looking at the forthcoming changes to EMIR reporting as a result of EMIR Refit, considering the exemptions applicable as a result of EMIR Refit and the notifications required, looking at the operational considerations, looking at the perspectives from other jurisdictions, and also looking at the forthcoming ESMA consultation deadlines regarding EMIR Refit. We'll then pivot and take a look at the global margin rules, focusing on an update on the delayed initial margin implementation for phases 5 and 6 and some of the history behind that, before finishing with a discussion on the securities financing transactions regulation and forthcoming reporting requirements that are going to arise under SFTR. So first of all, I am going to turn to EMIR Khoo to discuss forthcoming changes to EMIR reporting as a result of EMIR Refit. And EMIR, over to you.
Thanks very much, Ed. So as you may already be aware, the European Market Infrastructure Regulation, EMIR, came into force in August 2012 and forms part of the European part of the post-financial crisis international effort to increase the stability of OTC derivatives markets. The EMIR Refit regulation came into force in June last year and makes a number of amendments to EMIR, primarily to simplify certain requirements and reduce disproportionate costs for smaller counterparties to OTC derivatives trades. Article 9 of EMIR requires parties to derivatives transactions and central counterparties, CCPs, to report details of all trades and derivatives to a registered trade repository. Article 17b of the EMIR Refit regulation inserts new paragraphs into Article 9 of EMIR, which prescribe who is responsible for trade reporting, and I'll cover those in more detail now. As from the 18th of June this year, a financial counterparty, an FC, will be solely responsible and legally liable for reporting on behalf of both itself as an FC and for non-financial counterparties established in the EU or UK and not subject to the clearing obligation, known as NFC minuses. And the reporting requirements here is that the SEs would have to report the details of OTC derivatives contracts concluded between the SC and the NFC minus. To ensure the FC has the data it needs to fulfill its reporting obligation, the NSC- must therefore provide the FC the details relating to the OTC derivative contract concluded between them, which of course the FC cannot be reasonably expected to possess. If the NSC- wishes to continue to report these OTC derivatives contracts, they may do so, but they have to inform the FC accordingly. However, please note that on the 27th of April this year, ISDA, AFME and 3 other trade associations wrote a joint letter to ESMA asking for forbearance for a period of just over 5 months, so until the 21st of November this year, because, first of all, NSC- are unable to provide the data needed by FCs in order to report, and, or secondly, FCs have been unable to make the required preparations to support taking on this additional reporting obligation due to human, IT and operational issues, all related to the ongoing coronavirus pandemic. But the joint letter to ESMA flags that where NSC- have fulfilled their obligations of providing all the relevant data to FCs prior to the 18th of June, the NSC will no longer be responsible for reporting its trades. The FC will then have assumed liability for reporting OTC derivatives trades on behalf of the NSC- as of the 18th of June, even if the FC is not yet in a position itself to report the NSC- trades as of that date. But we're still awaiting an outcome and response from ESMA in relation to this request. Other changes from the 18th of June also include the following. If an NSC- concludes an OTC derivative contract with an entity in a third country, that OTC derivative contract will not need to be reported by the NSC- provided that, first of all, the third country entity would be qualified as an FC if it had been established in the EU or UK. Secondly, the legal regime for reporting to which the third country entity is subject is a regime that is declared equivalent under EMIR. And thirdly, the third country entity has reported the details of the OTC derivative contract pursuant to that third country legal regime for reporting to a trade repository, which is legally bound to provide access to the data to the entities referred to in EMIR. Also, from the 18th of June this year, if one or each of the counterparties in an OTC derivative transaction is a UCITS or an AIF, the management company of the UCITS or the alternative investment fund manager, as applicable, will be responsible for the reporting on behalf of that UCITS or alternative investment fund. The authorized entity responsible for managing and acting on behalf of an institution for occupational retirement provision that does not have legal personality will also be responsible for reporting the details of OTC derivative contracts on behalf of that scheme. There are also some key exemptions and notification requirements relating to those exemptions that may apply, and we'll go through those considerations now as well. First of all, there's the intragroup exemption from the reporting obligation. Derivative contracts within the same group where at least one counterparty is a non-financial counterparty are exempt from the reporting obligation if specific conditions are met. The counterparties to that transaction may be subject to the intragroup exemption from the reporting requirements, so long as both parties are included in the same consolidation on a full basis. Both counterparties are subject to appropriate centralized risk evaluation measurement and control procedures. And finally, the parent undertaking is not a financial counterparty. Counterparties intending to take advantage of this exemption first have to notify their competent authorities. The exemption will be valid unless the notified competent authorities do not agree upon fulfillment of the conditions for the exemption within 3 months of the date of notification. But in the UK, it's worth noting that the exemption shall be valid from the date the FCA confirms to the counterparty that the conditions to use that exemption are actually satisfied. But that's, of course, subject to any decision of any other relevant EU national competent authority in the case of intragroup transactions between a UK counterparty and an intragroup counterparty established in another EU member state. In terms of intragroup exemptions from the clearing obligation, under EMIR, meeting the criteria for an intragroup transaction doesn't automatically apply. So that means that there are certain situations that will only be applicable in terms of the intragroup transaction being exempt from the clearing obligation. So these are the following situations. In the case of two EEA counterparties, including if one is in the UK, both will have had to have notified their respective national regulators in writing that they intend to make use of the exemption for the OTC derivative contracts entered into between them. The notification must be made at least 30 days before using the exemption. A regulator can also object to the notification if specific requirements under EMIR are not met or cease to be met, or where one group counterparty is established in the EEA or UK and the other is established outside of the EEA or UK, then the EEA or UK entity must have been authorised by its national regulator to apply the exemption within 30 days of being notified of the EEA entities or UK entities' intention to rely on that exemption, and certain conditions under EMIR must in fact be met. So the following points should also be noted. First of all, the exemption does not automatically apply, and the relevant regulators must be notified in advance of it being used. Secondly, one regulatory notification does not cover transactions with multiple group entities. A party trading with two or more group entities must notify the regulator in respect of each counterparty. And finally, where counterparties are established in two different EU member states, and the relevant national competent authorities disagree on whether the relevant conditions are met, counterparties should not rely on the exemption. Over to you, Ed.
Thank you, Emma. So let's take a look at the operational considerations. And as Emma noted, EMIR Refit has made financial counterparties responsible and legally on the hook for the timely and accurate reporting of OTC derivatives, both on behalf of themselves and also for their non-financial counterparties, the NFC minuses that Emma was talking about. So to do this, the NFC minus has to provide the data to the financial counterparty that it cannot be reasonably expected to possess. And this brings complications and operational considerations for the financial counterparties. In particular, what information do they need and how do they get it? And this area has received a lot of scrutiny in the market. Here are some of the key points. Falling after that, considering just the quantity of data that needs to be provided by the NFC minus client to the financial counterparty, is the financial counterparty has to ensure that it has the NFC minus's LEI. And without this, it's not going to be able to report the trade. So that's a sort of fairly basic thing to get. But it's without that, it's impossible to report the trade. And the financial counterparty also needs to confirm whether the NFC minus still intends to report for itself. Now, that's the NFC minus's right to do so. Some of them will wish to continue reporting themselves, but this needs to be agreed between the NFC minus and the financial counterparty. And on top of these sort of more basic determinations lie more complex ones, such as whether a particular NFC minus entity will be in scope for EU EMIR reporting, or for relevant counterparties, whether the onshored UK EMIR reporting regime after this year's transition period ends for the withdrawal from the EU is going to apply. There are also some wrinkles not properly covered by the rules, and one of these is what happens when an NFC plus becomes an NFC minus. And there's a market view that the financial counterparty is going to be immediately liable to report on behalf of the NFC minus client, but it's not clear to what extent there will be liability for a financial counterparty if it's just not aware of that change. So although we hope there's going to be some regulatory clarification soon, this is the sort of thing that needs to be, obligations to notify this need to be put in place into agreements between the financial counterparties and their NFC plus clients, and also with their NFC minus clients, because the reverse can be true as well. An NFC minus counterparty could change in classification to become an NFC plus, and at that point it becomes liable for its own reporting as of a calculation date, and it's going to have to tell the financial counterparty to stop reporting so that they don't end up having both reporting the same trades. So here the key is to have a good framework agreement in place for applicable counterparties. And the third consideration here is the position of third country financial counterparties, because EMIR Refit doesn't impose any obligation on third country financial counterparties to report on behalf of themselves and their NFC clients. So if an NFC minus entity trades with an financial counterparty that's been established in a third country, the NFC minus counterparty is still responsible for reporting the trade itself. Of course, these are things that can be caught up and put in place in agreement between the parties, but there's just a trap there to be looked out for. So I'll now turn to Marcel to discuss the perspective from other jurisdictions. Marcel, over to you.
Thank you, Ed. As EMIR Refit is relatively new and as directly applicable EU law, should not be interpreted much different in the various EU member states, there do not seem to be any specific aspects from a German law perspective. However, in the recent months, we helped our clients a lot with updating their reporting documentation. And I think a few things we have learned in the course of this exercise are very interesting and worth sharing with you. EMIR forms part of the European regulatory response to the financial crisis and specifically addresses the problems observed in the functioning of the OTC derivatives market in the 2007 and 2008 period. So in May 2017, after carrying out an extensive assessment of EMIR, the Commission proposed a regulation amending and simplifying it in the context of its regulatory fitness and performance program, Refit, to address, inter alia, disproportionate compliance costs for certain counterparties, such as the non-financial counterparties below the clearing threshold we discussed. So one of these measures was that introduction of Article 9, Paragraph 1a of EMIR, introducing a simplification of the regulatory reporting requirements for such non-financial counterparties. According to such provision, from the 18th June this year onwards, the general rule is that financial counterparties shall be solely responsible and is explained legally liable for reporting the details of OTC derivative contracts concluded with a non-financial counterparty below the clearing threshold on behalf of both counterparties, as well as for ensuring the correctness of the details reported. To ensure that the financial counterparty has all the data it needs to fulfill the reporting obligation, the non-financial counterparty shall provide the financial counterparty with the details of the OTC derivative contracts concluded between them, which the financial counterparty cannot be reasonably expected to possess. And we have heard from Ed what the practical problems related to that are. The non-financial counterparty shall be responsible, however, for ensuring that those details are correct. So what sounds like a relief for non-financial counterparties below the clearing threshold, in practice is not always a relief for them, and also not for their financial counterparties. This is because the majority of such non-financial counterparties below the clearing threshold already have in place clearing and reporting arrangements with their financial counterparties and have delegated their reporting obligation to such counterparties. However, from the 18th of June onwards this year, there is nothing to delegate any longer under such agreements. So the reporting delegation agreements need to be amended or terminated. This is, of course, documentation effort for both parties, the financial counterparties, respectively clearing brokers, and the non-financial counterparties below the clearing threshold. Often not only the reporting delegation agreement needs to be amended, but also schedules under an ISTA documentation or a German master agreement or clearing master agreement, for instance. An amendment of such contracts often also makes necessary a cover letter explaining the changes made to the derivatives documentation for the non-financial counterparty and gives rise to questions, discussions between the parties. All this, in the view of many market participants, is not considered really advantageous, given that at the very end, the legal situation is not much different under EMIR Refit from 18th of June onwards, as it was before for such counterparties. When it comes to reporting, what had been contractually agreed between the parties has now been signed into law. However, there is only little, for some counterparties, if at all, practical benefit for both counterparties, which in the view of many market participants does not seem to be well balanced in light of such documentation efforts. Against this background, according to many counterparties, EMIR Refit brings the real benefit as regards reporting only to non-financial counterparties below the clearing threshold and their financial counterparties, which enter into a new derivatives documentation or which enter into the derivatives documentation the first time from 18th of June 2020 onwards. Thank you, and over to you, Ed.
Thank you very much, Marcel. And now over to Emma to discuss the forthcoming ESMA consultation deadlines regarding EMIR Refit. Emma, over to you.
Thank you very much, Ed. So, yes, as Ed said, there's just a couple of ESMA consultation deadlines regarding both EMIR and EMIR Refit. So, first of all, with regards to EMIR Refit, on the 27th of March this year, ESMA published a consultation paper on reporting, data quality, data access and registration of trade repositories, TRs, under the EMIR Refit regulation. The proposal basically builds on ESMA's experience since EMIR was implemented and aims to enhance the quality of the reported derivatives data. So among other things, ESMA is extending the current use of ISO 20022 XML for reporting to authorities through the whole reporting chain, from the reporting entity to trade repositories and among TRs for reconciliation. ESMA has invited responses, in particular from financial and non-financial counterparties of derivatives, CCPs and TRs, and from all the authorities having access to the trade repository data. And the deadline for comments is the 19th of June this year. ESMA will consider the feedback in Q3 of 2020 and will publish a final report and submit the draft technical standards to the European Commission for endorsement in Q4 of 2020. And with regards to the consultation relating to EMIR, on the 27th of March again, ESMA announced that it is inviting responses to questions set out throughout its consultation paper on its report on post-trade risk reduction services with regard to the clearing obligation that ESMA is drafting under Article 85(3)(a) of EMIR. The deadline for responses to this consultation paper is the 15th of June this year. Back to you, Ed.
Thank you very much, Emma. And now to turn to discuss the global margin rules and the update on the delayed initial margin implementation for phases 5 and 6. So let's go back to the summer of last year. And I've filmed an episode then for my YouTube series, Initial Margin in 2019 and 2020, asking whether the regulators would give us a break from the timeline to implement the initial margin rules. I've been out on the road in 2018 and 2019 giving seminars on initial margin implementation, and I went, amongst other places, and spoke in Frankfurt, Zurich, Copenhagen, Brussels, Milan, Hong Kong. It was a lovely road trip. And the area from the audiences which attracted the most interest was what reliefs might be available from the implementation of Phase 5 of the global margin rules. We had got to this point because, as listeners will recall, the requirement to exchange initial margin had been phased in across the EU from March 2017, a little after the US in September 2016, and it captured those counterparties with the largest derivative portfolios first, but then eventually was cascading down to counterparties with 8 billion euros or equivalent threshold of gross notional amount of outstanding uncleared OTC derivatives. Those rules, of course, captured those for whom derivatives was their business, the market makers, and then in annual expansions of the rules, less sizable institutions. So by September 2020 of this year, it was due that institutions, including asset managers, smaller banks, pension funds, and buy-side corporates with an aggregate average notional of 8 billion euros of derivatives would have fallen in scope for the exchange of initial margin. And these were institutions which, for some and for many, derivatives was not their core business, and they were struggling to put in place this very complicated infrastructure. Now, in the Give Us a Break episode I was filming, I discussed the derivatives industry's efforts, spearheaded through the trade bodies such as ISDA and SIFMA, to get the regulators to give it a break. And to make that point, I filmed some of the episode playing a game of pool in the 8 Club next to Bank Station in London. And the reason, and I outlined the reasons that the industry bodies argued that a break was due, had been set out by ISDA and SIFMA in a white paper. It was a concise 39 pages of detail covering the challenges faced by the Phase 5 entities, as they then were, and for financial institutions interacting with those Phase 5 entities. The white paper listed there being just this huge number of newly in scope counterparties, the extent of the operational and technological builds required, the rush of demand on market participants and service providers, and the need for industry-wide preparations to meet the legal and documentation challenge and have processes for collateral eligibility requirements and exchange of data and model approvals and similar. And this followed on from this were other industry lobbying efforts that sent by letter to BCBS, the Basel Committee on Banking Supervision, and IOSCO, the Secretariat for the International Organization of Securities Commissions, and copied to the key regulators with pleas to raise the gross national threshold for Phase 5 to 100 billion euro or US dollars from the existing 8 billion. And the reason they'd argued for this was that the vast majority of the 1,100 counterparties falling into Phase 5 would have been closer to the 8 billion the threshold, and this would have taken 85% of effective counterparties out of the mix. And I always felt that was something of a hard sell. There'd been other proposals to remove physically settled foreign exchange swaps and forwards from the aggregate average notional amount calculations, to have various model exemptions. The reason I cover that is say, well, what did we get? In July last year, BCBS IOSCO released a press release splitting the Phase 5 in-scope level so that only those entities hitting over 50 billion euro threshold had to comply with the initial margin rules by 1st of September this year. And they added a new Phase 6 for the club of entities who would be having the outstanding derivatives amounts of between 8 billion and 50 billion threshold, and gave them a compliance date of 1st September of next year, 2021. And this was met by loud cheers from the derivatives industry. But there was a catch. BCBS IOSCO announcements do not have the force of law. Now, that will surprise some, so I'll say it again. BCBS IOSCO announcements do not have the force of law, and these changes are at the option of global regulators and legislators, and they require amendment by legislation. In Europe, and let's focus on Europe, this requires an amendment to the EMIR EU Regulatory Technical Standards, the RTS, for margin rules for uncleared swaps. And so a draft RTS was proposed by the EU European supervisory authorities to effect this change on the 5th of December last year. And in accordance with the timelines in the EU for getting these through, This gave the European Commission up to 3 months to consider this, to write a report, with the European Parliament and the EU Council possibly taking as much as a further amount of months to approve this and give those changes the force of law, i.e. to make us have a split Phase 5 and Phase 6. And that would have been the plan, but for COVID. So once the extension of COVID disruption became apparent, and following further lobbying efforts from the same industry bodies, BCBS IOSCO announced a further deferral of the final implementation phases of the margin requirements. And BCBS and IOSCO agreed to extend that deadline for the Phase 5 and the new Phase 6 each by a year. And in a press release, did this on 3rd of April, i.e. last month. So this gives a real legislative headache to implement the changes in Europe, with similar headaches in the US, because they hadn't managed to get the previous RTS into law before this further change. So a new draft RTS to implement the prior extension that had been stuck had to be replaced, and this was released at the beginning of May. And if we follow those same EU timelines, this gives the European Commission a further 3 months to consider this second RTS, write a report with the European Parliament, and then the Parliament and its Council has a further month to approve the change. So let's just say timing's going to be tight. We still have Phase 5 taking effect according to law on the 1st of September this year. But the laws need to be passed by the European Parliament, and it's not like they're not busy with other things. So there's a real risk, and I would put this as more likely than not, that the legislation in the EU necessary to postpone the implementation of Phase 5 to create a new Phase 6 and have that pushed out to September 2021 and September 2022 is not going to be done in time. So this means that the regulators across Europe are going to have to allow what's called forbearance with complying with the EU margin rules, which is basically a regulatory let-off whilst the legislation finds its way into law. It's not ideal, and I hope I'm wrong. And this is going to be further complicated for institutions based in the UK, because this amended legislation comes into effect with the UK already having left the EU. And although there are mechanisms in place to bring these changes into UK law, regulatory forbearance is going to be needed in the UK as well. There is some further good news that there's a proposed model RTS on the horizon that would, with the idea being that there may be some relief for SIM backtesting and other model validation requirements, which will give some relief to counterparties that aren't as big or derivatives isn't their main business. So to finish, I never did end up releasing my Give Us a Break episode. It remains in editing. Continual updates to the rules, or likely updates, meant that it was moving too quickly to give the episode long-term relevance. But I will edit it together once we know the final settling of the rules. In the meantime, please, if you're interested, please do take a look at the series on initial margin in 2019 and 2020. Googling my name and initial margin will get you there. And with that, I turn to Emma Khoo to discuss the Securities Financing Transactions Regulation and forthcoming reporting requirements under the SFTR. Emma, over to you.
Thanks, Ed. So onto the second regulatory regime that I'll be covering. So the Securities Financing Transactions Regulation, also known as SFTR, came into force in January 2016 and aims to create a safer, more transparent financial system by placing additional requirements on counterparties in relation to securities financing transactions, SFTs. SFTs are defined in the SFTR as including repurchase transactions, repos, securities or commodities lending, and securities or commodities borrowing, a buy-sell-back transaction or a sell-buy-back transaction, or margin lending transactions. Broadly, the legislation requires SFTs to be reported to trade repositories, detailed reporting by UCITS management companies, UCITS investment companies, and alternative investment fund managers on investment fund SFT activity, and prior risk disclosure and written consent before counterparties are permitted to reuse or rehypothecate assets. The SFTR reporting requirements are currently being phased in according to the type of reporting counterparty and was supposed to be as follows. So on the 11th of April this year, the reporting obligation should have become applicable for Phase 1 firms, so investment firms and credit institutions and equivalent third country firms. But I'll go into that in a bit more detail shortly, as this was another regulatory phase that was impacted by the ongoing coronavirus pandemic. On the 11th of July this year, central securities depositories and central counterparties will start reporting. On the 11th of October this year, all other financial counterparties, including insurance companies, pension funds, UCITS and AIFs, and equivalent third country firms will also start reporting. And then on the 11th of January 2021, non-financial counterparties will start reporting. However, going back to the Phase 1 entities that have been affected by the pandemic, on the 26th of March this year, ESMA published its revised statement on the implementation of SFTR following feedback from financial market participants and stakeholders in light of the impact of the ongoing pandemic. As mentioned before, Phase 1 of the SFTR reporting obligations for credit institutions, investment firms and equivalent third country firms was supposed to apply from the 13th of April this year. However, ESMA recognised that the pressures on firms caused by the impact of COVID-19 on market volatility and volumes, as well as on personnel within firms, has seriously compromised SFTR implementation, especially completion of the necessary technical setup. So ESMA stated that it no longer expected local regulators to prioritise supervisory actions towards Phase 1 entities until the 13th of July this year. Instead, local regulators are expected to apply a risk-based approach to enforcing the applicable legislation in this area in a proportionate manner. Also, trade repositories were no longer expected to be registered before the 13th of April this year, but they should be registered sufficiently ahead of the next phase of the reporting regime, so on the 13th of July this year, in readiness for counterparties within the scope of Phase 1 and also those within Phase 2, so CCPs and central securities depositories, to report their SFTs. ESMA is continuing to closely monitor market implementation and the impact of the relevant measures taken with regards to COVID-19 to ensure alignment of SFT reporting requirements and supervisory practices in the EU. The SFTR reporting requirements leverage substantially on key aspects of derivatives reporting under EMIR. So, for example, both counterparties must report their side of the SFT unless one party can report on behalf of both counterparties by prior arrangements. Where one report is made on behalf of both counterparties, the report shall indicate this fact. Another similarity is that where a financial counterparty enters into an SFT with a non-financial counterparty, that's a small and medium-sized enterprise, an SME, the financial counterparty is solely and legally responsible for reporting both sides of the SFT to a trade repository. The third similarity between the SFTR and EMIR reporting regimes is that the SFTR technical standards set out what information needs to be submitted for each of the counterparties and what information shall be submitted only once. Either counterparty to the SFT may also delegate reporting to a third party, such as a third-party service provider, and some of you may recognise that under the EMIR reporting regime. Finally, where one counterparty reports on behalf of another counterparty or a third party does the reporting of an SFT on behalf of one or both counterparties, the information reported has to include the full set of details that would have been reported had the contract been reported separately by each counterparty. In terms of the impact of Brexit, now that the UK has entered into a transition period after leaving the EU, the transition period is due to expire on the 31st of December this year, EU law will continue to apply in the UK until the end of the transition period. So SFTR will directly apply in the UK during the transition period, but at the end of the transition period, this regulation will convert into UK law, so also known as being onshored, under the European Union Withdrawal Act 2018. So I'll hand over to Ed now.
Thank you, Emma. And with that, we end our talk today. Thank you very much to my co-presenters, Emma Khoo and Marcel Hörauf, and thank you very much to our audience for tuning in. A few brief reminders. You will receive an email with a link to the recording of today's call, and the recording will also be available as a podcast on your preferred podcast platform. Lastly, and as mentioned before, if you have any questions on today's content, please email them to gfm@mayorbrown.com. Thank you again for your participation. You may all now disconnect.